Just days into his second term, and President Donald Trump has already unleashed an unprecedented wave of executive orders, including limiting the constitutional guarantee of birthright citizenship. Now, for more on what exactly this means, we're joined now by constitutional law expert and historian Joshua Kastenberg. Josh, thanks so much for speaking with us today.
Thank you again for having me on.
All right, so the 14th Amendment states that American citizenship is a birthright for all people who are born on American soil. Take us through what this executive order would mean for that right, starting with what Trump wants to do exactly and what the significance of this move is.
Sure, it doesn't expressly state that in, plain language, but it comes pretty close, and it's been assumed under our constitutional law that that is the case. In fact, that has been assumed to be the case before the 14th Amendment. So what President Trump is trying to do is ordering the executive branch to not process individuals who were born in the United States, on United States soil, for citizenship if their parents were not here in the United States lawfully, or if they were here as tourists. In other words, he's trying to have the executive branch do something without the support of Congress, the say-so of Congress or the courts. It's kind of like past presidents who've said, I'm not going to issue the following people passports. But it's different because now we're creating stateless people if this is allowed to stand. And our country, the United States, has long been against the concept of stateless people living in the United States.
All right, Josh, tell us more then about the connection of birthright to citizenship and immigration. And specifically, I'd love to speak about the landmark case of the United States versus Wong Kim Ark and how that played a role in essentially guaranteeing birthright citizenship.
Yeah. There are actually Supreme Court decisions, one in particular prior to the 14th Amendment, that incorporated old British common law, saying if you were born in the soil of the United States, you were entitled to all of the protections of the laws as though you were a citizen, making you a citizen. Of course, citizenship changed after the Civil War. The concept of it became much more federalized. The case you've referenced, Wong Kim Ark, is critical in our constitutional jurisprudence. It was decided at a time of intense anti-Asian bigotry in this country. He was born in the United States to Chinese migrant parents. He returned to China. He was refused re-entry into the United States by California officials, I believe, who made the argument he's not an American citizen. He can't be because he had foreign parents and he's not European. A 6-2 decision of the United States Supreme Court. There was one justice absent, so it was down to 8 justices, but a 6-2 decision determined that if you're born on the soil of the United States, then you are a United States citizen. It encompassed birthright citizenship once and for all. And the assumption has long been, except for some people on the fringes, that in order to change that idea of birthright citizenship, you'd have to amend the Constitution of the United States, which has been done in the past. We had prohibition, and then prohibition went away. The voting age was lowered to 18 in my lifetime when I was a child, so it can be done. But in order to do that, if you're the president and you don't have a role in the amendment process, it's the Congress and the states that have that role. You have to trust the people of the country that you're right. And I think what the president is doing is, in this case, is not just anti-constitutional, it's anti-democratic, and it shows a lack of trust in the American people.
Well, Josh, how
Who
are
put him in office.
Yes. So how are U.S. states then responding to this executive order? Are they in support of it? Are they going against it? What are people saying?
Well, we have of our 50 states, we have different parties in power. So the Democratic Party states, governors, attorney generals right now are suing the president. And this is not unusual. Republicans sued Biden over the student loan forgiveness program and the like. So the states have standing to sue, and they're suing in the Northwest, but most of them are suing in the United States District Court in Massachusetts, in Boston, which has a long storied history of being the center of lawsuits against the federal government by states going back before the Vietnam conflict. And what they're arguing is that the president is acting unconstitutionally and it will create greater burdens on the states. That's what gives them standing. The issue, I tell my students this and the local news here in New Mexico, and that is before we even get to the moral questions involved, the first question is always about presidential power. Does he have the power to do what he's doing? And on all of his executive orders that he's issued, except one, I would say he has the constitutional authority to do what he's doing, as unpopular or popular as it may be. But on this one, he does not. And that'll go up to the United States Supreme Court. I have no doubt about that.
So, Josh, what are we looking at here timeline-wise? How long would this take to actually get to the Supreme Court for it to look at?
Well, that's in the hands of the Supreme Court. It can go rapidly because, of course, what will happen is a United States District Court judge in Massachusetts or in the Northwest will likely issue an injunction, a temporary injunction, ordering the White House to continue processing people. Then they'll hear the case on the merits. That can be rapidly done because, frankly, both sides have teed up their arguments already for this. It'll go to the appellate courts, and from there, it'll go to the Supreme Court. The fastest I've seen, historically, something go has to do with President Harry Truman's seizure of steel mills or President Jimmy Carter's departure of the country from the Mutual Defense Treaty with what was then known as the Republic of China that we call Taiwan. Those two cases made it to the Supreme Court within a month and a half. And there's no reason why this issue shouldn't rapidly go to the Supreme Court. Frankly, I would be shocked if the 9 justices on the Supreme Court were taken by surprise by this because, like I said, some attorneys and constitutional law scholars on the fringe have been arguing this issue in law review articles for a long time. And President Trump has made this a mantra for a while. So I think everybody's ready to go. And to me, there's no reason why it can't be rapidly heard.
All right, Josh, I'm curious then, how does birthright citizenship then compare to other countries such as Canada?
Yeah, so, in your home country of Canada, you have birthright citizenship through a specific law in 1977, I believe, and then you have your Bill of Rights in Canada, which is much newer than ours, and some would argue more robust in plain language than ours is. So birthright citizenship in Canada is, in theory, mirrors the way that we in the United States have viewed it since the 1890s. That is, if you're born on the soil of Canada, you're a citizen with a couple of limited exceptions, such as if your parents are foreign and in the employ of a foreign government. So let's say you have a mom or a mom and dad working in the Swedish embassy or for the government of Norway or of Japan, and they're in Canada formally, then the child is not a Canadian citizen, but otherwise one assumes that the child is a Canadian citizen. One thing I want to make a comment on that I didn't earlier is that it seems to me that the arguments that are being deployed now to end birthright citizenship are very close as an analog to the arguments that were raised back in the Dred Scott versus Sanford days of the United States, the notorious slave case, where the Supreme Court made an extraordinary decision that the color of one's skin determined citizenship. The Civil War was supposed to end that idea once and for all. And it seems like we're going back to arguments made prior to 1860. I don't think, from what I know about Canadian law, that would be a possibility based on the way that Canadian law has been shaped. I wouldn't have thought it was a possibility in the United States, but apparently it is.
All right, well, as we've said before, it's going to be an interesting next 4 years. Josh, thank you so much for joining us today and for your insights. We appreciate that.
Thank you for having me.
That is constitutional law expert and historian Joshua Kastenberg.